latest employment law and HR update. My name is Matthew Huggett and I'm an employment partner at Carbon Law Partners, and we have got quite a lot of content to get through today in the next hour. And in fact, there has been a stop press announcement. There's been quite a significant case that has just been published by the Supreme Court this morning, a case of Kostal versus Dunkley. Which deals with collective bargaining and trade union matters, which I've also just at the very last moment added into the slide, so we'll be covering that as well. But please do obviously grab yourself a coffee. Nobody can see or hear you, so you can just sit back at your leisure and hopefully enjoy the next hour if these things are enjoyable. But hopefully enjoy the next hour as we go through all of the latest information that we've got in the world of employment law. So what have we got? Well, first of all, in this first section, what I'm going to do is I'm going to cover the legislative changes or potential legislative changes that we're going to be having in the future. And the main one, or the most significant one, in my view, is in relation to the response that the government has published in relation to sexual harassment. Now, cast your mind back to 2018 and 2019 at the height of the Me Too movement. There were obviously a lot of various issues that were coming up in terms of sexual harassment and sexual harassment at work. And in the UK, we had the particularly high profile issues involving Sir Philip Green. And now, sort of as a consequence of that, the government published a consultation in 2019 to see what it was that they could do to sort of improve the protection for employees at work, to protect them from sexual harassment. And that consultation took place in July 2019, which obviously is now over 2 years ago. And everything all went very, very quiet indeed until a few weeks ago, when finally the government published the response to its response to the consultation. And there are three main recommendations. I say recommendations, actually proposals for legislation that the government have now come out with. And you'll see those on the slide here, which is, first of all, a duty on employers to prevent harassment. Secondly, that third-party harassment is to return, and also an extension in employment tribunal limits. So let's just have a look at these in turn. So first of all, the duty to prevent harassment. So the duty to prevent harassment. Now, as things stand at the moment, what we have got, as you can see, is set out in section 109(4) of the Equality Act. What we've got at the moment is not a requirement, but it is a defence that employers have got if they are sued, taken to the employment tribunal with a case of sexual harassment. So in effect, if an employer who would be otherwise vicariously liable for the acts of its employees, so if you had an employee that sexually harassed another employee at work, and as a result of that, the employee who was sexually harassed then sued the company, then the company would be liable for that sexual harassment unless it could then show that it had taken all reasonable steps to prevent that harassment from happening in the first place. But as you can see, that's purely a defensive mechanism for when an employer is sued. So unless an employer is sued, really it doesn't have to do anything. And in any event, the bar is set quite high in relation to this reasonable steps defence, or should I say all reasonable steps defence, because the word all is quite important here in setting how high that bar is in terms of an employer being able to achieve this. And so effectively, there is no onus really on employers to take any steps to prevent harassment. There is no obligation on them to have an anti-harassment policy. There is no obligation on them to train employees. So what it means is that, as I say on the slide, it means that employers can effectively do nothing. But what this proposal is going to do to provide a duty on employers to actually prevent harassment is that they must undertake these essentially undertake these reasonable steps. They must put in place efforts to prevent harassment from taking place in the first instance. So what happens if an employer doesn't do that? Well, if an employer doesn't do that, what the government have said is that it's going to be enforced by the Equality and Human Rights Commission. And there are various things that the Equality and Human Rights Commission can do. I mean, at the moment, they can put in binding agreements with employers. So essentially, in the same way that perhaps the Health and Safety Executive would issue improvement notices and come to agreements with employers about health and safety activities. It looks like it's going to be a similar way that the Equality and Human Rights Commission is going to address this duty of employers to take steps to prevent sexual harassment. And when I say sexual harassment, of course, actually it isn't absolutely clear from the government's response, but it's almost certain that what the government is intending to happen here is that there is going to be a duty on employers to prevent harassment, to prevent all forms of harassment. So whilst the consultation itself was very much focused on sexual harassment, that this is going to go wider and it is going to apply to all of the protected characteristics, all 9 protected characteristics. So it is going to up the ante in terms of what employers have to do. And personally, I do think this is a bit of a game changer, because there are many employers out there who either don't have policies or have insufficient policies, who might have a policy that was put in place a number of years ago but haven't refreshed the policy, haven't communicated the policy or recommunicated the policy, haven't updated the policy to deal with social trends, so haven't updated the policy to deal with things such as trans issues or menopause issues and so on and so forth. And so this is very much an upping of the ante. Now, in terms of whether in reality it's going to have the intended effect, but of course we're going to have to wait and see, because it's going to an extent, it's going to depend upon the actual powers that the Equality and Human Rights Commission are going to be given, and also whether they're given the resources to actually police this or not. So this is a really very significant step, I think, in terms of harassment legislation, discrimination legislation generally, because it is going to shift the training and the activities that a number of employers have from a nice to have to a really we must have, to very much a compliance issue, rather than simply it'll be nice to have this, so perhaps we might be able to defend a harassment claim if we have it, rather than actually positively taking steps to prevent harassment in the first instance. In terms of timescales, when this might be coming into force, this isn't going to happen overnight. There isn't draft legislation at this point. What I would expect that to happen is that for this to get announced in the Queen's speech of May 2022, and then for it to probably come into force sometime in 2023. But I'm having a little bit of a guess there, but that is the sort of timescale that I expect us to be dealing with. So that's the duty to prevent harassment. Now, the return of third-party harassment. Now, for those of you who are old enough, you may remember that when the Equality Act was first introduced in 2010, there was what was called the 3 strikes rule that provided for third-party harassment, which was set out in section 40 of the Equality Act. Essentially, that meant that as soon as somebody was harassed on 3 separate occasions by a third party, and it could be different third parties, and that wasn't set out over any particular timescale, so it could happen over the course of, say, for example, 10 years or a couple of days. But then that individual could then bring a claim against their employer for the harassment that they have been subjected to. There were various problems in the way that was actually working. And one of the ways in which it was shown not to be working was also in the case of Unite the Union and NAILARD, which, as you can see there, which decided an NHS trust was not liable for the racial harassment of a nurse by a patient, because its failures to take adequate steps to prevent the racial harassment weren't in themselves because of race. And so we've essentially had this really unsatisfactory situation, both since the original law was repealed in October 2013 and the Nailard case, which has left employees exposed to harassment by third parties. And so the government has now committed again to essentially having another stab at this, to reintroduce rules, but new rules that are going to focus again on this all reasonable steps to prevent harassment by a third party. So you can see this is going to be very much tied in with the duty to prevent harassment generally. And when they say it's going to be very much focused in on the all reasonable steps, then of course, then the question is, well, what does that mean? What does all reasonable steps mean? What do we have to do to be able to successfully achieve all reasonable steps, to take all reasonable steps? And the government have said that they're going to ask the EHRC to publish codes of practice and guidance in this area. But what they're not going to do, they're not going to mandate what all reasonable steps should be. And they say that because they want employers to have flexibility. They also appreciate and understand that all reasonable steps in one organisation is going to be very different to all reasonable steps in another organisation. So it varies, and they don't want to mandate what all reasonable steps should be. But of course, what that means for us as employers is that it's a bit difficult to then be able to assess, well, you know, what are the reasonable steps that we're going to have to take? And it leaves it uncertain. But certainly as a very much a minimum, that is going to require us to have policies. It's going to require us to communicate those policies effectively. It's going to require us to train people on those policies and on the issues and on social trends to make sure that the workplace is keeping up to date with the way that society is changing in respects of the standards that individuals are setting, because it's all about the standards that individuals set in the way that they expect to be treated, rather than necessarily the standards that we set within our own business, because we've got to reflect the way that society is changing in that regard. So so a lot of unknowns really there in relation to third-party harassment, but certainly a change which is necessary to provide appropriate protection for people. And then the final one is in relation to the extension of time limits for discrimination claims in the employment tribunal. So at the moment, as I'm sure many of you will be aware in any event, everyone has got to bring an employment tribunal claim within 3 months of a discriminatory act. Now, when we're dealing with unfair dismissal claims, then that's all very straightforward, because when we're dealing with an unfair dismissal, then there is a set date on which that happens clearly, and everybody's mind is then focused very clearly as to when the time limit is going to expire. And it's very clear that you know, it's very rare for those time limits to be missed, or should I say it's quite easy for them to be achieved. Now, with discrimination claims, that's somewhat different, because harassment, sexual harassment, any other form of harassment can take place during employment, and it doesn't necessarily mean that the individual has been dismissed. So they can be treated in a discriminatory way, which can give rise to a claim. So say, for example, if I was harassed at work, and I was harassed at work today, but I then raised a grievance about it, and then that grievance process then extended over the next 2-3 months because of the complexity of it, because of the difficulties that there might be in terms of the investigations and appeals, etc. But the discriminatory act has still happened today, and I've still only got 3 months from today within which to put that employment tribunal claim in. And of course, there are also, I've come across many instances of claimants where the period of time over which somebody has been harassed has been quite significant. It might be a number of months, it might be a number of years. And so then we then get into arguments about whether those discriminatory acts that are more than 3 months ago are permitted to be brought to the tribunal. And so one way of resolving this, the government have concluded, is to extend the time limits, to have a 6-month time limit. But what they have said in relation to this is that they are very conscious of the fact that the tribunal system is at the moment under a huge amount of strain. There are long delays in the system, not due to any fault of the great work that's being done by everyone working in the employment tribunal environment at the moment, but simply because of the volume of cases and the resources that are available. And so with that in mind, the government haven't indicated any date by which they are going to start extending these time limits. So they're going to monitor the situation. So this is very much a case of watch this space. So don't know quite when that is going to happen. So those are 3 very significant changes that are going to be coming in the future. And as I said, the most significant one in my mind is the duty that is going to be placed on employers to prevent harassment, because this is going to be a bit of a game changer for the steps that employers will have to make as a matter of course to prevent harassment from taking place in the workplace. Now, many of you may already have arrangements in place. Many employers do, but also sadly many employers don't, and they're going to have to up their game in order to comply with these new requirements. Continuing the theme of sexual harassment, there has been a report that's published by the Fawcett Society. And as you can see here on the slide, the report is identifying that 40% of women, at least 40% of women, have experienced sexual harassment during their careers, and that there have been reports of higher levels of sexual harassment, both within ethnic minorities and also disabled employees. 7 in 10 disabled employees had indicated that they had been subject to sexual harassment. And so what we have got here is, I guess in a way these figures might be somewhat depressing, but they're not necessarily that surprising either. And what the Fawcett Society are doing, because obviously they're a campaign group that play a significant part in trying to keep the discrimination legislation and protection for employees at work from sexual harassment up to date and keeping the pressure on. And what they are going to do is they are going to publish a toolkit in January of next year. Now, of course, this toolkit then, alongside perhaps the code of practice that is then going to come from the Equality and Human Rights Commission, is going to be quite useful for employers to then be able to ensure that then once the legislation then comes into place in terms of the duty to prevent harassment, that if we're then doing what the Fawcett Society are setting out within their toolkit, and also what the EHRC is then setting out within their code of practice, then of course that means we're going to be in a good place to be able to ensure that we're meeting this new duty. Now, in terms of this toolkit, what the Fawcett Society are saying that we should have is that, or the main points are that obviously employers need to change the culture. And when we're talking about changing the culture, of course, we're that's sort of encompassed with diversity issues, generally making sure that we're recruiting from a broader group, that there is appropriate balance of gender across the organisation. And then there's the obvious things, such as taking all forms of sexual harassment seriously, treating employees who report sexual harassment with respect and empathy, rather than dismissing their complaints or essentially not dealing with them in the appropriate way, taking them at face value in the first instance. And one of the other recommendations that they make is actually that we should ensure that, of course, that there is anti-sexual harassment training, but that should be mandatory. It shouldn't simply be on induction, that it is something that is refreshed on a regular basis. And also perhaps even considering having a separate sexual harassment policy. Now, I know a number of you will then be thinking, well, if we have a separate sexual harassment policy, does that mean that we now start to have a look at having separate harassment policies for other protected characteristics. And I personally don't think that is necessary. I don't think that you can be criticised for going above and beyond in relation to sexual harassment, and that in some way waters down your approach to other protected characteristics. But I can see that that could be something that employers could be challenged upon. But certainly, we'll obviously be making all of the subscribers to our email updates aware of this toolkit as soon as it's published, and then we can certainly help you put in place the actions that are recommended as part of that toolkit. The next point is gender pay gap. Now, I know that obviously any employer who has got more than 250 employees has been required to report on their gender pay gap for the last 3 years now, probably a little bit more than that. Sorry, I'm losing track of the dates. Time does fly. But now the Equality and Human Rights Commission and also the Chartered Management Institute have got together, and they created what they call a practical toolkit to support organisations drive action. So essentially, this isn't about how you report gender pay. This is about, well, how do we address the issues that gender pay, our gender pay statistics have really given rise to, and this has particularly been triggered by the fact that one of the things that has been identified in the statistics that have been coming through is that as a result of the pandemic, and I say as a result of the pandemic, certainly during the pandemic, the COVID pandemic, is that the gender pay gap has got wider. And so that is one of the reasons why this guidance has now been published to try to help employers to address the matters that are coming out of their gender pay gap statistics. So the link is there. Now I appreciate that you can't click on the link during the session, but what I will do is after we've concluded this webinar, we will of course be sending out the slide deck to everyone, and within that slide deck there will be these links. So don't worry, you'll still be able to get hold of that information nice and easily. Now, for those of you who have been attending these sessions on a regular basis, you'll have heard me talk about the reporting of ethnicity pay gap for some time. And the reason that we've been reporting on it for some time and be saying to employers, well, this is likely to come at some point, so perhaps start getting yourself ready for it, is because we still expect it to be coming along at some point. And you should therefore start to, or continue to get yourself ready for it. But again, we go back to the whole consultation on this goes back to 2018. We're now over 3 years down the line, and we still don't have any firm proposals from the government in relation to the introduction of the ethnicity pay gap. Now, the update to give you is that on the 21st of September of, well, obviously this year, so 21st September, so just over a month ago, there was a debate in the House of Commons that was forced by one of these online petitions. So there was an online petition to try to nudge the government along in relation to to this matter. And what the government have said, what Paul Scully, the Parliamentary Under Secretary of State, has said, was that essentially they still haven't concluded what they think the ethnicity pay gap reporting should look like. And that's because they've got a number of concerns, and those concerns relate to the need to ensure that the sample size is large enough to enable valid conclusions to be drawn from any data that's published. Because, of course, with gender pay gap reporting, there is normally, not always, obviously, but there is often a reasonable comparative sample size of men and women within the organisation to be able to have valid statistical information then coming out of that. With the ethnicity pay gap reporting, the government is concerned that actually the sample sizes might not be significant enough in many organisations, which is then going to result in sort of ebbs and flows of data, which then aren't statistically valid and therefore are going to be reporting in an inaccurate picture. So that's one of the concerns that they have. They also are worried about other skews in relation to data, because are employers going to have to report on simply the pay data for white and non-white employees, or does it need to be broken down any further than that? So they're still grappling with it, although quite why they've been grappling with it for 3 years, I don't really understand. I'm sure they could have sorted it out during this period of time, but we are hoping to hear something from them in due course. But they haven't given any timescale as to when they are going to publish their response to the consultation. So as you see with the consultation on sexual harassment, the government has now published its response and indicated what legislation it's going to introduce. With the ethnicity pay gap reporting, we're not even at the stage of the government responding to the consultation, which, as I said, was 3 years ago now. So yes, it's still watch this space, but also don't hold your breath. One of the other issues that has been coming to the fore now, of course, again with our other updates, if you've been on top of our other updates that we've been reporting on issues such as gender fluidity, gender identity, trans issues. One of the other issues that is coming to the fore in terms of employment and discrimination is the menopause. And the Women and Equalities Committee, which is an important committee within within Parliament, because what the Women and Equalities Committee does is it makes very significant recommendations in relation to equality issues. And so the Women and Equalities Committee has conducted an investigation, or should I say is conducting an investigation, into discrimination in the workplace because of menopause. And so what it's doing is it's having a look at the experiences of women in the workplace, the discrimination that perhaps they are being subjected to. And when I say perhaps subjected to, I mean, there was a 2019 survey conducted by Bupa and the CIPD, which found that 3 in 5 menopausal women, usually aged between 45 and 55, were negatively affected at work, and that almost 900,000 women in the UK left their jobs over an unidentified period because of menopausal symptoms. And so clearly there is an issue here that needs to be addressed. And so what the Women and Equalities Committee are doing is having a look at whether there is anything that can be done or should be done, either from a code practice point of view or from a legislative point of view, to ensure that this isn't happening, to ensure that 3 in 5 menopausal women aren't negatively affected at work. Now, of course, we have already got a number of potential areas where women are already protected under law, both under age discrimination, sex discrimination, and disability discrimination. But this, again, is really very much a case of let's watch this space. But also tied into this, there was an interesting case which was reported very recently, which actually dealt head-on with the issue of the menopause and the definition of disability. Now, this was I was going to say a rather unfortunate case, but certainly the Employment Tribunal hearing was rather unfortunate because but the Employment Tribunal struck out the claim on the basis that it concluded that the woman wasn't disabled. And that is despite the fact that the judgment recorded, and I'll just sort of read out some of the things that the judgment did say. So the judgment recorded that Miss Rooney had given evidence that her symptoms included hot flushes, sweating, palpitations, anxiety, night sweats, sleep disturbance, fatigue, poor concentration, urinary problems, and headaches, and also that her symptoms had led to her forgetting to attend events, meetings, appointments, losing personal possessions, forgetting to use the handbrake on a car, forgetting to lock it, leaving the cooker and iron on, and leaving the house without locking doors and windows, and spending long periods in bed due to fatigue and exhaustion, and experiencing dizziness, incontinence, and joint pain. Now, when we go back to as we see here on the slide, the definition of a disability is a physical or mental impairment which has a substantial long-term adverse effect on ability to carry out day-to-day activities. And in interpreting the whether the effect of those of that condition is substantial enough, all any claimant has to do is show that it's more than minor or trivial. And so although the employment tribunal struck out this claim on the basis that they considered that she hadn't showed that her condition was substantial enough for it to constitute a disability, the Employment Appeal Tribunal did overturn that decision by saying that they can't understand why the tribunal could come to that conclusion on the basis that they'd accepted the evidence that, as I just read out there, of the symptoms and the consequences or the impact of that the condition was having on the woman. So certainly that's going to be a useful case for any claimant to be relying upon when they have got an individual who is suffering from the menopause. And from an employer's point of view, of course, that means that we've got to be more aware and more open about discussing menopausal issues and looking at reasonable adjustments that can be made for women who are going through the menopause, rather than just simply ignoring it. Flexible working, I'm sure you'll have all probably seen the recent proposals that have been put forward, or should I say again, the consultation. Sorry, I'm being a little bit loose with my language there. So the consultation that the government has launched in relation to flexible working. And what they have proposed is that the existing right to request flexible working, which has been in place for, as you can see now, over 17 years, that those proposals should make it now a day one right. So at the moment, you've got to have 26 weeks service of employment to be able to make your application for flexible working. That's now going to become, or the proposal is that that now should become a day one right. That they're considering making changes to the 8 business reasons for refusing a request to work flexibly. And one of the things also, just to bear in mind here in terms of the way the regulations operate, is that when we are giving one or more of those 8 statutory reasons for refusing flexible working, there is no actual requirement at the moment for an employer to show that the reason that they have, or the conclusion that they've come to in relation to that reason, is in fact a reasonable conclusion to come to. So there isn't a reasonableness test here. Now, of course, yes, there is the potential issue in relation to indirect sex discrimination and also disability discrimination that we always have to be particularly aware of when we're dealing with flexible working requests. But it will be interesting to see what changes may be made around those 8 business reasons. There's also potentially the actual requirement for an employer to suggest alternatives to the arrangement. So at the moment, once an employee puts in a statutory request, there is no need for the employer to do anything other than to consider that statutory request. And even though it might accept something slightly different to that statutory request, there is no requirement for the employer to go back and discuss it. It can just simply reject the original request that's made by the employee, turn that down, and the employee then can't make any further requests for another 12 months. So the requirement for the employer to go back and suggest alternatives is, I think, quite an important one in this proposal. Changing the administration process, well, we'll just have to wait and see what that actually means. The administration process, in my eyes, isn't particularly onerous at the moment. It used to be in terms of the timescales, but we'll have to wait and see what comes out of that. And also a raising of awareness in relation to a right to request a temporary arrangement. Now, I've got to admit, and I think most people are thinking this as well, is that really this all seems a little bit toothless. I mean, the right to request from day one doesn't really substantially change anything. There is no default for flexible working to be the norm in any way, as has been pushed for by a number of organisations. And of course, given that actually post-pandemic, a lot of organisations are voluntarily embracing flexible or hybrid working, perhaps in a way that hasn't been done before, is that actually any changes to these regulations are probably going to be, I wouldn't necessarily say a little bit late, but just aren't going to have any effect because employers will be ahead of the game. If you do want to submit any views on this consultation, then as you can see, there is an email address there, should you choose to do so, because the consultation is still open. And then, not quite finally, on the sort of legislative issues that are going on at the moment, because I've just got one more to turn to after this, but just thought I'd bring to your awareness a report about the benefits and negatives of hybrid working. Now, of course, you may have worked this one out already, because as I said, a lot of organizations, both during the pandemic, of course, because it was forced upon us all, but also post-pandemic, are embracing hybrid working. Of course, some can't. Some do need everyone to be on site. So I don't want to make any assumptions about the fact that this affects everyone in quite the same way, because obviously, if you're working in a care home, if you're providing important public services such as, whether it be health services, the NHS, the police, ambulance, and so on and so forth, the manufacturing sites, many organisations cannot work from home or even work in a hybrid way, but there are lots that can, and of course, many of those organisations are now simply embracing this hybrid working. But this survey, so most workers were hoping only to return to the office 2 or 3 days a week. And over half were concerned that working remotely would mean that they missed out on learning from peers and senior colleagues. And that statistic is very much demonstrating a bit of an age difference here in terms of the effect that hybrid working or remote working is having on people's careers. Because I, for one, I certainly know that in my formative years of learning my trade, is that it was actually sitting alongside people who had the experience and working alongside those people and learning from them. And if you're trying to do that remotely, then that's very difficult indeed. And so, even though it might on the face of it seem like a great and wonderful solution for many, for others who might still be having to work from their bedrooms or kitchen tables, it isn't, and that particularly affects the younger age group. So I would certainly encourage you all to be, and I'm sure many of you are, but to be thinking about the effects of hybrid working and the fact that it might not be a one size fits all for everyone. I'm just pushing through all of this content because I appreciate that I've got an awful lot to get through, and as I said, I added in another case at the beginning of the case update, which is going to be coming in a moment. Now, sorry, I will just make this slide a little bit bigger so that you can see it. So COVID vaccinations, just to remind you all that, well, I say remind you all, remind anyone that works in the care sector that care home workers will be required to be fully vaccinated from the 11th of November. There's also been a recent survey that said that, looking beyond the care home sector, that 70% of organisations are looking to mandate vaccinations for their employees. Now, I do have a separate update on whether employers can force employees to have vaccinations. Essentially, existing employees, no, you can't do unless you're in the care home sector and it's being required by legislation. Some employers are introducing it as a requirement on the offer of employment. But as you can see here, there is now judicial review, which is now challenging the vaccination requirement for care homes. So this legislative change that's been made by the government, that is being challenged on the basis that the government hasn't considered appropriate alternatives, that there is an undeniable right to bodily integrity, and that it's also having a disproportionate impact on women and Black Caribbean and Black British people in breach of the equality legislation, the equality legislation from Europe, and that's going to, in any event, it's going to lead to a shortage of care home workers. So there is a challenge that is going on. Quite when that will be dealt with, again, not quite sure about that. It's well, I'm not sure of what the timescales are. So that is coming now. Just very briefly before I move on to the the case law update. I just wanted to make you all aware of the sorts of services that we can provide. Don't worry, I'm only going to spend one moment on this, but just to let you know that for our employer clients, we provide a number of different support packages, or fixed price support packages that you can use to get support from us. So you can start off with the compliance, which provides a health check and annual reviews, and reviews all of your policies and procedures and contracts, and does so on an annual basis to keep all of that up to date for you. We can also provide a pre-purchased hours package, which essentially you buy time with us at a discounted rate, and then you can use that for advice and training and tribunals. And then our peace of mind package, which is essentially you pay a fixed price, you get all the advice that you need. That can include employment tribunal claims as well if you want, and also some training, which could also include the sort of equality type training that I've been talking about in relation to the new duty to prevent harassment. So if you're interested in any of that, then obviously please do get in touch. Now, don't worry, let's move on to the case law update. But I can see I've just had a question that's come in relation to where you can find the report about hybrid working. It's a report that's been produced by an organisation called Poly, P-O-L-Y. I will put the link in the slide deck when it comes out in any event. Okay, so it will be, you will have that when I send it out. Now, this is the hot off the press case. Now, I accept that this is only going to be relevant to those of you who have got recognised trade unions, and also where you have collective bargaining in place. And so given that it's not going to apply to everyone, I'm not necessarily going to spend a huge amount of time on it, but what I am going to do is I'm obviously just going to run through the circumstances of the case, because this is a very important case for those of you that do have collective bargaining in place. So essentially, the facts of this were that the company Kostal was in negotiations with the union, and as you can see here, they put forward an offer to settle their pay negotiations, but that offer was then rejected. As you can see here, 78.4% voted to reject the offer. After that offer was rejected, the company then wrote to all employees directly to make that same offer to them. And the letter stated that if they didn't accept that offer by the 18th of December, they would not receive the Christmas bonus, and the Christmas bonus being the third part of the offer that was made. They then continued with the pay negotiations with the trade union. No agreement was reached, and then by the end of December, the company and Unite the Union then reached stage 4 of the dispute procedure and referred the matter to ACAS. And then actually by January of January 2016, the company said that they had nearly 96% of employees had actually accepted the offer. They decided to take the money. Now, the law in relation to this is quite interesting because essentially it dealt with this issue, section 145B of TOLCRA, which is all about inducements related to collective bargaining. As you can see, I've just put in bold here the important bits of this, which has said that essentially an employer cannot make an offer directly to an employee if the consequence of doing so is that the terms of employment are then no longer going to be determined by collective agreement. And so that then means that essentially what that is then trying to do is trying to stop the employer from effectively undermining the collective bargaining process. In terms of the decisions that we had at the various levels of the court, so the employment tribunal upheld the complaints that were made by the claimants. And what that then came to, and as you can see here, we then get to a really very significant sum of money, which is why this is not why this is such an important case, but there are significant consequences in relation to this case. So they awarded £3,800 to each claimant who was made an offer on the 10th of December, and there was also an additional award of a further £3,800, which is a statutory award for any employee that then received a second offer that hadn't accepted the first offer, of a further £3,800, giving a total compensation sum of £421,800. £421,800. So the EAT then heard an appeal that was made by the employer. They appealed the decision, and the employer was then successful. And the union then appealed that. So the Court of Appeal then allowed Kostal to appeal, and then the Supreme Court, sorry, I'm getting this a little bit muddled, aren't I? But essentially, the Employment Tribunal upheld the complaints. The EAT then upheld the appeal. So actually, that's why I've got a little bit confused, because I haven't quite written that right. So the EAT upheld the appeal that was then made. The Court of Appeal then overturned everything and said actually Kostal could do what they were entitled to do. And then the Supreme Court has now allowed the union's appeal. So effectively, we have gone back to where we were, which is the £421,000. But there is one important point that's come out of this. Well, in fact, there are many important points that come out of it, but one important point in particular, which has said that, and I know there's a lot in this slide, and you can have a more detailed read of it when I send the pack out to you. But essentially, there is nothing to prevent an employer from making an offer directly to its workers, provided it has followed and exhausted the agreed collective bargaining procedure in the first instance. And of course, what we've got in this case is that Kostal were stepping in and they were beginning to make offers to its employees directly before the collective bargaining process had been exhausted. Now, if they'd waited for that bargaining process to have been exhausted, then what they had done would have been perfectly fine. So what this doesn't do, so it doesn't give the union an absolute veto on preventing an employer from going directly to its employees. It's just that the employer has got to exhaust that collective bargaining process before it does so. So for any employer that is going into dispute with its trade union in a collective bargaining process, this is now a very important case indeed, and one that is certainly welcome in the fact that it's giving clarity in a number of areas. And I know that there are a number of employers who have been waiting keenly for this, and the trade unions that have been waiting keenly for this result, so that we can have some certainty in this area. Now, another important case that we have had recently. Now, I do have to put a bit of a caveat on this case, because this case is only an employment tribunal case. And when I say only, it means that other employment tribunals aren't bound by this decision, but it can be used in a persuasive way. But this is particularly when we go back to the issue of hybrid working and whether we are now requiring people to come back into the workplace. This is really a very significant issue indeed. So it's all about whether associative discrimination can apply in indirect discrimination cases. Now, what the law says at the moment, so Section 13 of the Equality Act, which deals with direct discrimination, also says that if somebody cannot be treated less favorably because of their protected characteristic or because of the protected characteristic of someone that they associate with. But then when we look at indirect discrimination doesn't bring across this associative discrimination point. So indirect discrimination, in the way that the Equality Act is worded, only applies to the individual that has that protected characteristic. It doesn't apply in circumstances for someone that they associate with. But this is where the Equality Act is a little bit out of kilter with European legislation, because European legislation actually, when it deals with indirect discrimination, it doesn't require claimants to have that protected characteristic. And so this case of Follows and Nationwide Building Society has sort of grappled with this issue. And so just to put this into context, and this is the sort of issue that I've been finding quite a few employers are dealing with at the moment. So this is where the Mrs. Follows was the circumstances were effectively that she was working from home because she was the main carer for a family member who was disabled. So Mrs. Follows wasn't disabled herself, it was her family member who was. So she was associated with somebody who had the protected characteristic of disability. And she'd been working from home since 2011. And in fact, the reason that she was working from home was because of the fact that she had these caring responsibilities. But then come 2018, 2019, I can't remember the exact date, but that's not really necessary. It was actually 2018, 2017, 2018. So she was dismissed in 2018, January 2018. But Nationwide Building Society was then going through a reorganization in 2017. And they were reducing the number of people that they had in the role that she undertook. And as a result of that, because it had supervisory elements to it, they wanted to bring her back into the office. And so they insisted that she did. And they said that if you don't come back into the office, then we are going to dismiss you. They had another employee who also worked from home in the same role, who was also treated in an identical way, but he didn't have any caring responsibilities. And so the direct associative discrimination claim that was brought failed because she was treated in exactly the same way as someone else in the same circumstances. With the indirect associative discrimination claim, she was successful though, and the Employment Tribunal pointed to the requirements of the European Race Directive and that case that was on the previous slide, the Shea case, and they said that actually there was a PCP here, a provision, criterion, or practice, that is the requirement to work from the office that was in place, that placed Mrs. Follows as someone who associated with someone who is disabled and at a disadvantage, and would also place anyone else within that group, anyone else that associated with someone who was disabled, to the extent that they were caring for someone in their home at a disadvantage, and that they couldn't justify the treatment of requiring to bring her back into the office because she'd been successfully working remotely since 2011. And so the reason why this is so relevant, of course, is that we're coming across many situations at the moment where we are bringing people back into the office, whether that be under hybrid working, so 2 or 3 days a week, or perhaps even 5 days a week, where they have been working from home successfully during the pandemic and have now perhaps picked up caring responsibilities that perhaps they didn't have before. And so we're now going to have to potentially consider whether the bringing back into the office is going to be reasonable and proportionate. Now, this isn't triggering reasonable adjustments. Reasonable adjustments is a slightly different test. But in effect, there is an awful lot of overlap between indirect discrimination in this regard and also reasonable adjustments. So actually, the concept in terms of what you've got in your mind probably isn't going to be that different. But what we've got essentially what we've got in the meantime is we've got a little bit of uncertainty. Certainly what I would say to you is that it's going to be very prudent of you to address these issues in a way that, consider ways in which you can manage the return to work of your employees post-pandemic back into the workplace where they have got caring responsibilities. And actually, do you need to bring them back into the office in those circumstances? And just to also pick up on, some of you who might be thinking, well, hang on a sec, but we're out of Europe, and this is a European case that we're referring to here. The Shea case is a European case from 2014, and the Race Directive is of course European as well. But as you can see, that I've set out this slide, that the UK courts are still required to take into account pre-Brexit European Court of Justice decisions. but they are entitled to depart from them if it appears right to do so. So essentially, we need this case to be appealed so that we can provide a bit of certainty for everyone here. But certainly it is, again, it's this case has probably got a much wider reach than the Kostal case, because this is going to come up more regularly on a day-to-day matter. Now, because I have at the last moment put in the Kostal case into my slide deck, it does mean that I've sort of run somewhat over in terms of, or may run somewhat over if I was going to cover off all of the other cases that I was going to do in relation to COVID. What I will say is I'll skip over the cases that I've got in relation to COVID. But what I will do is I'll set out to you the real principles that we're coming across. And to an extent, it's really fairly obvious. I mean, what we've got in law is that we have got a number of provisions, both, as you can see here, we've got Section 104 of the Employment Rights Act, which means that employees cannot be dismissed if the reason or the principal reason for the dismissal is because of one of these reasons. And most of these in relation to COVID has been dismissal for raising health and safety concerns, or dismissal for leaving or staying away from a dangerous workplace. Those are the issues that have been coming up. And there is a very similar provision for under Section 44, which is all about detriment. So it's not about dismissal, but it's about detriment. So employees who have been subject to a detriment where they have raised issues about health and safety within the workplace. Now, there are a number of cases now, and unsurprisingly, all of these cases that I'm just going to skip through now, all of these cases refer to employees that have got less than 2 years service. And so the employer has taken a fairly, how should we put it, fairly relaxed attitude to process and reason. And so what has happened is that, you know, in this Rendina case, we've got an employee with 3 months service who, after starting work, she raises concerns about mask wearing and the limiting of the number of people present within the vets where she works. Her concerns were dismissed. She follows it up with a detailed email about recommendations from the British Veterinary Association. She then refused to attend some procedures because she saw them as non-essential and that was placing her at risk. And then she was dismissed because of, as you see here, from the level of discord that she was presenting. And that was quite clearly an automatically unfair dismissal under Section 100. And these other cases repeat the same sets of circumstances. So Gibson and Lothian Leisure. So an individual who is employed as a chef was placed on furlough, but that was then asked to come in and help out for a bit. He then expresses concern about, because his father is vulnerable and he's obviously concerned about the steps that are being taken to prevent him from catching COVID and then passing it on to his father. And he's then simply told to get on with it. And then shortly later, on the pretext of redundancy, he's then dismissed by text. Again, automatically unfair because it was the concerns that he had raised, which was actually the underlying and main reason for dismissal. And again, that then gets repeated in the Fortuna Group case here, where an employee was refusing to travel into work on public transport and said that they could safely work from home. And then again, they were dismissed for general ongoing failure of your part over a period of many months to support and fully comply with our company policies and guidelines. When in fact, really, it was because they didn't want to come to work on public transport. And then again, we just simply continue the similar sorts of themes. Someone was given an instruction to deliver some equipment to their manager at their home where they were self-isolating, and they refused to do so in the way that they were instructed, and they were then dismissed, and again, automatically unfair because of the concerns that they were raising in relation to health and safety. We're also seeing an increase in whistleblowing claims because of, I say because of course, the issue of raising health and safety matters can also be covered by the public interest disclosures requirement under that fourth bullet point there, a danger to health and safety of any individual. So we're seeing an increase in health and safety related claims and also whistleblowing claims as well. And then the final case, I know I'm just hitting my time limit, but the final case just deals with an issue of dress codes, because I mentioned in the agenda when people were booking on that there was quite an interesting case in relation to dress codes. Now, this is an interesting case to the extent that the claimant, as you can see here, was of Muslim faith. This is a European case, so it's not a UK case, but the claimant was of Muslim faith and wore an Islamic headscarf, and she was employed as a carer which ran child day care centres, and then the care centre then issued instructions requiring its employees to observe a requirement of political, philosophical and religious neutrality. She was asked to remove her headscarf. She refused to do so, and actually it was found to be actually be fair to require her to remove the headscarf. The Advocate General in this case concluded that the ban on wearing political, philosophical or religious symbols is not direct discrimination, and that indirect discrimination could in these circumstances be justified. So a ban on conspicuous large-scale signs of political, philosophical or religious beliefs in the workplace can be justified. And freedom of religion may not necessarily be considered when examining whether the legitimate aim is appropriate and necessary. So arguably, this case does erode the protection against religious discrimination by elevating the concept of neutrality within the workplace, which may be welcomed by some and not by others, but quite an interesting case nonetheless. And that really concludes our session. I do hope you found that useful. I know that I've got one last question here about whether there is any news about whether the mandatory vaccine will move to domiciliary care as well as home care. There is a consultation that started. Sorry, I should have mentioned that when I was talking about that side. The government has started a consultation in relation to that, but we aren't any further in terms of having an outcome to that consultation. So it really is a bit of a case of watch this space at the moment. There's no news about it being extended at the moment, although of course we have had Sajid Javid giving indications that he is actually looking to extend it into the NHS as well. So we'll have to keep an eye on that. What I'll be doing, as I said, I will be sending out the slide deck to you. Please do also sign up to our email updates and also our podcasts. We do regular podcasts, more regular podcasts than we do these employment law update webinars. So please do sign up for those. We also do video updates as well. This will be going on to our YouTube channel as well. So please do go on there and subscribe. So I'll provide all of those links when I send that through for you to be ensuring that you're keeping up to date with that information. But that, yes, I appreciate I'm 4 minutes beyond, but I do hope that you don't mind and that hasn't delayed any lunches or anything. I hope that you found that useful. If you do need anything further, then please do get in touch. You will all obviously have my email address because I've popped the email out to you with all the login details for today's session. So if you need anything, get in touch, and yes, do just keep an eye out for our other updates. But thank you very much for booking on this section, and I do hope I haven't had to rush through things too much, but the Kostal decision which came out this morning sort of somewhat was a little bit of a curveball for me, but I wanted to make sure that we covered that for you all. So anyway, thank you very much and have a good rest of the day. Bye.